Good evening, everyone. Welcome to Special Education Legal Fund's November webinar, IEPs versus 504 plans. What's the difference? My name is Christine Lai, and I am Executive Director and co-founder of Special Education Legal Fund. Today's featured sponsor is American School for the Deaf. Founded in 1817, the American School for the Deaf was the first permanent school for the deaf in the United States and a nationally renowned leader in providing comprehensive educational programs and services for deaf and hard of hearing students. The American School for the Deaf is a long-term partner of SELF, and we are so pleased to have their support on our webinar series. Just a quick word to thank the remainder of our sponsors. Oops, did I do that? Yes, I did. Sorry. Resume share. Just a quick word to thank the rest of our sponsors, WealthSpire Advisors and Winston Preparatory School at the gold level, and at the silver level, American School for the Deaf, as I said, Fusion Academy, Shrub Oak International School, Villa Maria, Chapel Haven, and at the bronze level, Eagle Hill School and the Windward School. Yes, I know that it's not showing right now. I will fix that in a second. And a quick word on us for those of you who don't know us. Hopefully I can get a screen up so that everyone can see this. Special Education Legal Fund our mission is to provide resources and knowledge to families in need with children in the special education system. We were founded in 2018 to provide those resources as well as knowledge and support to families in need with children in the special education system. And since then, we have provided over $550,000 in grants for legal support to over 160 families across 60 school districts in Connecticut and Westchester County, New York. Our legal assistance program for attorneys and our advocacy support program for advocates are currently accepting applications for both programs. The legal assistance program provides families in need with up to $5,000 in legal support from a qualified special education attorney. The advocacy support program provides families in need with up to $1,000 in support from a qualified non-attorney professional advocate. And for more information or to begin the application process, please visit our website at www.spedlegalfund.org, and the tab is Apply for a Grant. Little advertising for our next webinar series. Our December webinar will focus on the new Connecticut IEP and will feature a presentation by special education attorney Jeff Forte and special education attorney Jill Hornig from the Forte Law Group. So please join us on December 7th at 7 o'clock, same time, and you can register for this webinar the same way that you did for the one that we're having this evening. Our first panelist is Piper Paul, special education attorney extraordinaire. We're so happy to have Piper back on this webinar tonight. I think this is, like maybe your fifth webinar. I don't even know. Piper is extraordinary in taking a hands-on approach with her clients, and she understands firsthand the challenges that parents with children that have special education needs go through and that they go through. Piper has a background in criminal law as well as special education law, and she has been focusing her advocacy efforts on the legal and civil rights of children with disabilities for most of her career. So thank you, Piper, and welcome. Our next panelist is special education attorney Dana Jonson from the law offices of Dana Jonson. Dana is an exceptional person. She's one of these people that kind of walks the walk, as well as talks the talk. She has a background as a special education teacher, a special education administrator, and she's also the parent of how many? 4 children? 4 who all have IEPs or 504s. So she knows very well what it's like to sit on both sides of the table, actually on all sides of the table. So we're really excited to welcome Dana. Dana is also a welcome and repeat guest on our webinar series. So thanks, Dana, and welcome. Our next panelist is Virginia Blum. Virginia is an extraordinary special education advocate who has joined the Connecticut Educational Advocacy. Is that it? 4 years ago, working with advocate Jill Chuckus after completing the COPA SEAT 2 training a few years ago. And Virginia is an active participant in the community and also comes to this work through a personal connection to advocacy and special education law through her daughter, who, was your first client, I guess. So welcome, Virginia. And last, but certainly not least, we are excited to welcome Diane Willcutts, special education advocate. Diane is an education advocate with extraordinary experience, over 20 years of working with families in Connecticut. Diane has many specialties in which she works with, but she has a particular interest in and gravitates to children and students with dyslexia. And this is also one of Diane's, multiple visits or multiple appearances on our panel series. So we're happy to have her as well. Welcome, Diane. And last but not least, we welcome Lara Damashek as our moderator for this evening. Lara is a special education advocate through Early Insight Advocacy and a CSE representative at the Windward School. Aside from that, Lara is a former special education attorney who practiced law in New York City with Schuyler Law and also has experience both as a public school teacher as well as a mom of a student with a 504 plan, I think, if that was. Lara is also a member of the Special Education Legal Fund Board of Directors, serves as its vice chair, and sits on the Grant Review Committee. So welcome, Lara, to this call. This really wouldn't be a webinar if I didn't read a little disclaimer for everyone this evening. This webinar panel is presented for informational purposes only. This webinar is intended as a resource for families who are navigating the special education system in Connecticut or New York and is not intended to provide legal support, advice, or assistance to any particular individual, nor is it intended to replace the advice and counsel of a qualified special education attorney. Families in need of legal advice, support, or assistance should contact a special education attorney licensed to practice in their area to discuss the specific needs of their individual student. This webinar should not be construed as an endorsement by Special Education Legal Fund or any of its representatives of any of the participating attorneys, advocates, or other professionals in the panel, nor should it be construed as an endorsement of any school or school representative that might be invited to appear on this panel. And so here we are, IEPs and 504 plans. I'm going to turn this over to you, Lara. Go ahead.
Okay. So we'll start with an easy question. I'll just pose it to the whole panel. Whoever wants to jump in, feel free, but we want to understand the difference between an IEP and a 504. So who would like to describe for us in simple terms what is an IEP?
I can do that. Hi, Dana Jonson again. So an IEP is an individual education plan, and that is the legal document that describes your child's special education program and all the aspects of it that the school is obligated to provide. And it comes in one document called an IEP. I don't know if that's what you wanted.
Yeah, perfect. Okay, so who wants to take the next easy question? What is a 504 plan?
I'm happy to do that. Sure. Okay. 504 plan is based on the Section 504 of the 1973 Rehabilitation Act in conjunction with the American Disability Act. They work hand in hand. It's important that that's noted. So in essence, a child has to have a disability. It has to have a substantial impact, and you have to show for a certain amount of time. And then the idea is to level the playing field. And the question becomes, what are the reasonable accommodations to level the playing field for those who do not have disabilities? The other thing is, it's confusing. Sometimes people call health plans 504. Health plans are a form of 504. And additionally, encapsulated within the IEP The 504 language is on the accommodation modification. So if you have an IEP, you don't need a 504. If you have a 504, if they want to give you a health plan, fine, but it's not necessary.
Okay, so when would you advise a parent to pursue a 504 plan versus an IEP?
Well, I think the biggest difference in some of that is their academic impact, right? So you don't think so? Well, so I would look at academic impact, and or if there's a disability, but maybe I'm wrong.
Well, I don't mean to be rude. I hear this come up a lot, and actually I hear it a lot when I'm in meetings with school staff, where they think that a child can only have an IEP if there's academic impact. And in fact, it's educational impact, which includes more than just academics. So it could be social emotional, it can be communication, it can be behavior. And fortunately, in IDA, the Individuals with Disabilities Education Act, there is a couple lines saying that basically we need to provide special education to students, even if they haven't gotten failing grades and even if they're passing from grade to grade. So, that to me is really important. And I mean, for me, if a student, if we're going to pursue just a 504 plan, it means the child doesn't need special instruction. So if the child just needs accommodation, so that could be something like, sitting in a part of the room, taking tests in a quiet environment, that kind of thing, getting extra time. If the child, if their needs can be met that way and they don't need instruction, that's fine. Sometimes school staff will say the disability isn't bad enough to need an IEP, so that's why we're doing a 504. And it's regardless of the severity of the disability. If the child has a qualifying disability and needs special instruction, it's an IEP. And it doesn't matter if the special instruction is in academics or organization or social skills. And this is a debate I have with school districts all the time. So
and I think the bigger issue is its educational impact. And I think,
yes.
And I think that's what Virginia meant to say, is educational impact. We in our field, we know the difference between educational and academic impact. In the world of special education law, it's very specific to say academic versus educational. So educational in the world of special education covers more than academics. It, as Diane just said, it covers the behavioral, it covers the emotional. I would say if I have a child who's in middle school and they don't have any friends, but their grades are fine. Well,
right.
I don't think that's fine. That sounds like educational impact, because I don't know another kid in the middle school who doesn't have friends or isn't, social during the school day or whatever those pieces are. So that's the debate that I think we all have with school districts on a regular basis, is which Diane is expressing her frustration over.
Yes.
is that, we have to explain to school districts on a fairly regular basis that education is more than academics. And it's really important for families to understand that whether you're talking 504, IDEA, education is more than just academics. And that, I think, is the bigger takeaway that we're trying to express.
Yeah, I think you look back to Child Find, and what is the mandate for schools? It's to evaluate in all areas of suspected disability. So if you have a child with visual impairment, a sensory issue, behavioral dysregulation, transition challenge, all those things where they need individualized instruction, social skills, sensory strategies, pragmatic language. Academics are not, it is not about academics. And you will hear that always, 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 always. They have great grades. It's not true. That's not what the law says.
And it's helpful because it's not in the law, and it's also, there's guidance There are written guidance documents from the U.S. Department of Ed that spell all of this out. And so sometimes it can be helpful for parents to provide that information and, you know, read aloud in the meetings. And really a lot of school district staff genuinely don't know. So it's not that they're necessarily, you know, sometimes there are bad intentions, but sometimes there aren't.
So like, let's pick a common example. I'm sure many parents out there can relate. But if I know that my child has ADHD, for example, what should I be pursuing? Do I need to know what I'm pursuing? Can I just ask the district to evaluate my child? What would be better if my child has ADHD diagnosis?
So if you have a diagnosis, you can go to your school district and say, I have a diagnosis. I have ADHD. My child needs extra time, as said by this expert. You know, this doctor said they need extra time. I need a 504 for that. And you'll have your 50, and that's extra time. Now, it might not just be extra time. There are other things, feeding up front, having assignments broken down for them, things that those are accommodations, right? So that's under 504. And then, but for IDEA, I'm sorry, I just totally lost my train of thought. I'm sorry, I have a dog in the room. And
You have specific goals.
I'm going to pass to somebody else because I just lost my train of thought. So I'm sorry.
I think what Dana was saying was this. So an ADHD diagnosis could be provided by a psychiatrist. It could also be very brief by BASC or brief objective testing. But it's kind of a red herring. What does that exactly mean? So what that often can mean are challenges with executive functioning. Often comprehensive neuropsychological evaluations are required. You have to look at initiation, switching, focus, concentration, and really target executive functioning. And you're not going to get it from the BASC or the brief, and you're not going to get it from a diagnosis from a psychiatrist. So that's really important.
Yeah. And I think thank you, Piper. I think one of the things I was trying to say was when you're talking about 504, you know, and you're asking for, I did it happen again. I'm so sorry.
Asking for accommodations.
We're all good friends. You know what? And I couldn't make the slides work. So everybody is fine.
Sorry.
It's
You asked, the question was, why would you ask for a 504? Why would you do that? The other reason you might ask for a 504 is like a physical diagnosis. You have some kind of physical issue or medical issue, right? You have ADHD, you have mono, you broke your leg. You need accommodations because you have this disability, which may be permanent, it may not be permanent, but you need these accommodations to get through school when this thing is happening. When you're looking for the IDEA for special education, you're looking at this child is not going to get these things through accommodations. This child is not going to learn through osmosis, and they're going to need specialized instruction in order to learn how to write that paragraph.
So they might need accommodations, but they need more.
I'm sorry, you're correct. They might, and those accommodations. Yeah, sorry, go ahead, Diane.
Okay.
Yeah, no, I guess in part, sometimes what districts will do is say, okay, the child has ADHD, so we will prompt them to write down their homework. We will prompt them to hand in their homework. We will prompt them to make sure that they have all their materials, and we can just do that through accommodations. However, with an IEP, you can move the child towards independence. And so sometimes we're saying, listen, that's not enough. We need the student to be independent and to have IEP goals that say, okay, they're going to independently write things down and they're going to independently hand things in within the teacher specified time frame and things like that.
But I guess
I just wanted to say one thing. Sometimes a 504 plan is enough. So like, I think that some of the sometimes when I talk to a parent, you know, I'll have a parent that says, I'm not sure. So maybe we're going to do testing and do that. Or maybe they want to see, like, let's see if this is enough. It also depends on how old the child is, where they are. So sometimes I do think that it is appropriate to just put a 504 in place and see where we are. You know, and I think that you can have that conversation with the school district too, and explore it, or you can do the testing to see if it takes it to a level that we need to put more in place now. And that's, you know, certainly something that can also be discussed, but sometimes a 504 is the right level of support.
Right. Well, if I have a child with food allergies, I would say absolutely, I don't need special instruction related to the food allergies.
But if
But
I'm
yeah.
Right, but there is an important,
there's a
there's a flip side to that though, which is sometimes parents come to us and say, we want the 504, we don't want special education. And because we don't want a label, or we don't want whatever the reason that they've been told by somebody that they have to not do that. And I think what's also important to recognize is you do not have the same protections under 504 as you do under the IDEA. So there are many more protections for families and children. So if your child qualifies for special education, please take it, because you're going to have more protections over getting those services. Accommodations, it's a different ballgame. It's a different statute that we're working under, and you don't have the same level of protection. And there are other ways to remedy that and to hold schools accountable, but you know, just it doesn't always go one way or the other. Sometimes the misunderstanding can go both ways.
And so what you're saying, Dana, just to, you know, just to jump in, is that, you know, if your child has a 504 and has ADHD, and maybe they're not, you know, making a lot of progress in school, you know, that is not necessarily that's, you know, under accommodations plan, you know, I mean, you don't have as much protection.
Yes. And not to get too into technical pieces, but the other side to this that we have to keep in mind is just because a child isn't failing doesn't mean there's no academic impact. I know we've talked about educational, but just because they're getting C's doesn't mean there's no educational impact. What if this child is brilliant? They should not be getting C's. That's not appropriate. So there's more to it than just, you know, looking at grades or, you know, whether they need an accommodation or not. So I always recommend, if you think your child needs any of those things, request an evaluation, request a full evaluation. That's the only way you can really get the information that you need.
And will the same people at the district, oh, sorry. So if I'm just making the referral, I'm not sure if my child needs a 504 or an IEP. Is it the responsibility of the school districts to explain the different options available, the 504, the IEP?
Well, the district has a responsibility for child find under both laws.
Yes.
However, I strongly recommend that families pursue getting an evaluation under special ed, regardless. And the reason for that is, say the district does all their testing, and at the other side, the family's thinking, I don't agree with it, or I think they missed something. With special ed law and an IEP, or in that process, the parents have a right to request an independent evaluation paid for by the district with someone the parent chooses. So that applies to special ed law. It doesn't exist for Section 504. So if you say, can you test my child under Section 504? And then you disagree, or you think they didn't assess in all areas of suspected disability, you don't have a right to an independent eval. So that's a really important distinction. The other important distinction between an IEP and a 504 is an IEP has goals and objectives, and they have to be measurable, and they have to be individualized to the student's needs. With a 504, you don't have to have goals and objectives.
What that means in English is they're held accountable, right?
Yeah, they're held accountable.
What that means in English is that they are paying attention to your kid, checking to make sure they're making progress. And if they are not making progress, you get to hold the school accountable. That's under the IDEA.
Well, I think, go ahead, Diane, I'm sorry.
Oh, no, go ahead. I'm on a rant. Go ahead.
I think you have to be families have to be exceedingly careful. A lot of times they're like, yay, my kid's got a 504. But then they're having like modified grades, modified assignments, but they're like Diane said, they're not becoming independent, and they're not really learning. And And there's really no teeth in that. And sometimes also I'm finding districts are kind of doing IEPs, but calling them 504s. And they're trying to circumvent, in my opinion.
All right.
the law.
Yep.
They're
Like, is it,
circumventing
we
the
used to
law.
say, there used to be this thought that out there that like a 504 was like special ed light, kind of, just not as much.
Yeah. Yeah. And
There any
I
truth to
think
that?
I think that sometimes districts view it as a consolation prize or something, you know, okay, we're going to not provide your child with special ed services and give you goals and objectives. We're going to give you something though. And what's interesting to me, students with a 504 plan are covered by Section 504, that particular law. Students with IEPs are covered both by the Individuals with Disabilities Education Act and Section 504. What I love with Section 504, I actually use this even with my kids with IEPs, particularly if I've got a gifted child. There are FAPE standards, standards for free and appropriate public education. These standards exist in IDA and it exists in 504. And it's not really well defined in either situation. What's cool with IDA is FAPE means that you have to have ambitious goals and it's in light of the child's, abilities. But 504 says that we have to meet the needs of a child with disability as adequately as we meet the needs of other students. And to me, that completely raises the bar, because if I have a gifted child and I'm giving everyone else the opportunity, the educational opportunity to meet their abilities and meet their potential, I have to do the same thing for a child who's gifted. So, a gifted child getting C's, they haven't had meaningful opportunity to achieve at their level.
One thing I find I've done different presentations. 504 and ADA are partners. They are intertwined with one another. So when I bring claims, it's for IDEA, 504 and ADA. 504 cannot exist without ADA. And that's where all the definitions come from. That's the language that the providers need to write. They are intertwined. So I think you also need to bring 504 ADA, they're together.
And when you start to think about, just skipping ahead a little, your child going on to post-high school, college, is there one that carries more weight in that regard, having had an IEP or a 504?
It shouldn't, because basically you can't have an IEP, obviously, in college. They're not required to provide special instruction or anything
Can
in
you
college.
just give a little background on that? Why can't you have an IEP in college, just if any of us are not?
It only goes to
right.
age 22. And it's covered by the LEA, the local education agency, also known as your school district. Colleges are not bound by IDA. They are covered by Section 504. So they do have to provide accommodations. It's not supposed to make any difference to the college whether or not you had an IEP or a 504 plan. I periodically hear from parents who say the college really wanted an IEP versus a 504. I said, talk to the Office of Civil Rights. I don't think they're going to go for that. But absolutely, it's the same standard for K through 12 in terms of accommodations as it is in college. They can get extra time, they can get flexible seating, they can get copies of notes, things like that.
I just want to clarify something, because I know what Diane was saying, but if somebody didn't know, they might be confused. Children are entitled to special education until they are exited from special education. Or turn 22.
Yeah.
So if you never meet all your goals and objectives and you never make, all whatever, when you turn 22, you're done with special ed.
Yeah.
So and you can't be, I shouldn't say you can't. If you are in college, you have finished high school. So there's the debate when we talk about children with disabilities as to where and when transition services are provided, but that's a whole different conversation. But my point was just,
Right.
yeah, it's just that, I'm sorry, I didn't mean to interrupt you, but I just
Yeah.
wanted to clarify that you
No,
can't
that's
get
a good
special
point.
education until 22, but if you are graduated from high school and in college, then you don't qualify. So that's all I was trying to qualify.
Right.
And I think I
Like
made it more complicated.
the district isn't
No, that was
paying
good.
for your full-time tuition at UConn. So
Right,
and
exactly.
generally, I was going to say,
No,
go ahead.
I was going to just jump in because I literally just did this process with my daughter, who is on the spectrum. She had an IEP. We applied to college. She does not have an IEP. She does have a accommodation plan. So, you know, one thing to keep in mind, if you are at that place, I did not feel that the process was at all skewed for her in terms of what she came in and had versus not. I don't think it at all had a factor in the decision. But we did have to have a very good comprehensive evaluation to give to the college within 2 to 3 years. And I think that's important to note. If you have and want accommodations after your child has graduated from high school, you need to make sure that you've kind of gotten some evaluation process done through them, or you have to do it yourself.
But a lot of
also
colleges
some
have very specific testing requirements. So
Yeah.
sometimes you can have certain tests done and they want other tests. And so sometimes it's,
Yep.
you know, it's,
Yeah, they're not supposed to. It's not
Well,
supposed to be a high
yeah.
bar
I
to
actually kind of-
document it. But oh, go ahead.
I kind of disagree in maybe, okay, so I handle a lot of, so once you are exited from special education, even if you met academic requirements, if you had social, emotional, those other challenges, you can walk, but the district can still be responsible. I have kids in college where the districts are still paying for the 504 ADA piece and also in other transitional programs. So, but what is imperative is once you are completely exited from special education for life, you have you're protected by the American Disability Act.
Right.
Again, in college, it doesn't matter if you have a 504 or an IEP. If you have a disability and your providers follow the language that is clearly encompassed within ADA, then that is good. If you had evaluations conducted prior, like through the district, you can still use those in college.
I'm sorry, I was saying we had those, that we didn't have to go back and get it. You're right. I didn't need to just right. We used the stuff that helped her get the IEP, but we just had it, you know, you just have to be careful about how old she was, right? Like,
Because it has to be within 3 years for
3
it
years,
to
right.
be
And
valid.
she was 20 when she graduated from high school. So we were a little older. So like I was just, you know, but thank you for clarifying. Absolutely.
So I just have a clarifying question. Maybe other people have the same confusion as me, because when I think of a 504 plan, I think of the school, the public school creating the 504 plan to, you know, ensure equal access. So for you, Virginia, for example, you say that she has a 504 plan in college. Who is creating the 504 plan? Who's the 504 team?
The disability
disabilities office.
at her college created that for her. It was not, look, again, she's old enough to need to be able to have all these skills. So the important skills of self-advocacy, of talking for herself, of identifying.
So that becomes the responsibility of who, Christine? The disability office in each?
It's called the
It becomes-
Office of Student Services
It
or the
becomes the
Disability
responsibility
Services
of the
Office.
student. It
Okay.
becomes
I
the
was gonna say,
responsibility of the
yeah.
student.
That's so,
And-
again, that was why it was so important to build, as Diane was talking about, like the other skills, and the, you know, it wasn't all academic, but
Right.
you know, the social skills, the self-advocacy skills, the ability to understand what your disability means to you and how that affects you, the sensory piece, the loud piece, and the, you know,
Well, think of it this way. If one of the top reasons adults with disabilities are unemployable are their eating habits. Who would think that that's something you need to teach in high school, like eating habits? Like they're all disgusting, right? I have 5 teenagers, they're disgusting. So like who would, you know, but I'm just giving a very basic example that, you know, that's a skill you need to have to be successful as an adult. So that's a skill your school needs to be teaching you.
All right.
Oh, on the college piece, I do a lot of this work, or for the work piece. And what occurs is where this is often getting lost is in the language is not being used by the doctors or the providers to clarify the reasonable accommodations. For instance, anxiety is one of the leading disabilities in colleges or in many places. So what does that mean? Does that mean that you get to test or register early for classes? Does that mean that you don't have more than one test in a day? Can you do stop the clock? It's the accommodations list is so long. And it's a lot more than just extra time. And
Oh yeah, it could be your own room.
Really,
Yep,
The other
absolutely.
part to that is
Yes.
there are certain tests, like say taking the bar or for medical school or the LSAT, whatever they are. Some of them won't allow you to take accommodations you have not historically taken. So that's another piece, because there's sometimes students who are like, I'm going to tough it out and I don't need to get, and I don't care if my grade isn't that good because I'm going to prove to myself I can do this without my accommodations.
Right.
And, you know, valiant
Use it or
effort.
lose it.
Yeah, I mean, you do you,
Yeah.
but you know, if you do that, then you may lose the opportunity to have that accommodation in the future.
I think you make it harder. You can go back retroactively. So I have represented, people going through med school and law school, and they could make it up to a certain point. But kind of what Virginia was saying, now you got to go backwards to go forwards.
Right.
You have to get the comprehensive eval to document things, and then you can do it. But you lost time.
Yeah.
So you won't lose it, but you created extra work.
And that's an important point, Dana, not only for these, I can't speak, the law exams or the CPA exams, but also ACT, SAT. I mean, I don't know where testing is going to go in the future with all this, test optional stuff. But if you want to apply for the college boards to give you extended time or a change of setting or whatever, you kind of want to have proven that you've needed that over the course of your high school.
Another thing on the 504 IEPs, I often have specific language for standardized testing. Those are different kind of tests. So I like the language clearly defined and delineated for those tests. For instance, you can have stop the clock. You can have testing over multiple days. You can have testing 45 minutes at a time over 3 weeks. You can, there's so many accommodations for these.
Not transferring to the bubble sheet, like, sometimes that's really hard. Whatever, your student needs to fully show what they know.
And you want that separate language on those 504 ADAs to distinguish and differentiate between the overall global accommodations.
I did want to mention one thing, and it'd be interesting to see what the other panelists say, but one thing I run into with a 504 is, having school districts tell me that we can't attach a related service to a 504. I don't know if that's something that was going to be brought up, but you absolutely can. Now, again, if they might need a related service, maybe we need to pursue the IEP. So that's a whole different question, but counseling, speech, any of those OT, if you have somebody that, has a weak pencil grasp that needs a little bit of OT, but doesn't need, more than that, we can attach that to a 504. So you can have related services in a 504. And I often have that as something where a team will say, well, I can't attach, I'm not going to attach speech service, I'm not going to attach the related service. And I'm successful at getting it attached if that's all we need.
So we had one question where we were wondering if there are certain scenarios in which a child might not qualify for an IEP, but you think a 504 might be sufficient. I was not as familiar with 504s that can recommend services. I feel like I'm often told that it's not for a service. But now that I think of it, I have seen them. So what would be, a certain scenario where you feel like a student would probably be fine with a 504 plan? Are there any examples? I know we used the ADHD one before.
Sometimes counseling.
That's what I was gonna,
Yeah, sometimes counseling is a good example where, the kid might need somebody to check in with and debrief or whatever that, but they don't need like specialized instruction. They don't need to
What about a
learn, be
one-to-one
taught
or
how to manage their
you get
emotions.
a one-to-one or an aide through a 504 plan, or do you need?
I mean, if you have like
You could,
yeah,
yeah.
absolutely. If you have a kid that has like a physical, we talked about that where like we can't write, but we know what we need to say. We can have a scribe. We can have somebody there that's looking at that. If that's all that child needs is that person to help with that skill. But again, it goes back to the, it's so hard because it's such an individual process. Like, it's hard to, there's not a blanket statement. I don't think I could make a case for that child needing an IEP too, because we want to teach them the independent skills that Diane talked about. It depends on what
I will always look for an IEP if there's any possibility that the child can be made independent and not need the accommodation.
If you
So
I'm
working with a child with traumatic brain injury, and she has difficulty with walking, standing, eating, speaking. And the staff basically said she can have a 504 plan and she's got an aide and, that's fine. And I said, well, she's got 2 aides helping her in the bathroom. We would like her to be able to use the bathroom independently. And they looked at us in absolute horror. It's like, and she can't eat a meal. I mean, Dana was talking about eating. It's like she couldn't eat in a way that would make other people feel uncomfortable around her. And, and we said, oh, and we need adaptive PE. Well, surprise, adaptive PE is special education. So, it isn't just about, so 9 times out of 10, if someone comes to me and says my child has a 504 plan, 9 times out of 10, there are goals and objectives we want them to meet. We want them to make progress towards independence. So usually we need an IEP.
I agree. I think the framework for this is what IDEA is all about. 3 things. Independent living, to be gainfully employed, to go on to higher education. If any of those areas are not working, you need the instruction in these areas. And they're often missing. How do you become as independent as possible? How do you go on for higher education or training? How do you be gainfully employed? And I always think of it this way. Congress said, hey, school districts, you're on the hook to try to educate and prepare people for life. Here's the money and the funding. After that, it's on the government. So the schools have a tremendous responsibility here. And often those individualized skills and training are required, regardless of grades or anything else.
Right. And if the students can't be independent, I mean, students with disabilities, high risk for not graduating, high risk for being unemployed or underemployed. So all those times when I'm working with a child with autism and they, are always asking you about SpongeBob and always asking about your socks, and they don't know how to engage in, a job interview without talking about SpongeBob or whatever. They're not going to be able to get a job. And so when I'm saying no, okay, it's great that everyone here understands him and thinks that he's really quirky, but our goal is for him to become as independent as possible. So we want to, they'll say, well, that's not really our responsibility. We're looking at what's happening in the school building. And as Piper said, I mean, the goal of special education, and this is in the law too, is further education, employment, and independent living. So we have to look at things outside the school building.
Right. And that is to prepare you for those 3 things. So if you have ADHD and you are going to college, you should still have transition goals and objectives. Are there any skills or, skills that you need to be successful in college. You can be as smart as you want to be. If you don't know how to fill out the application, or you would tank an interview, doesn't matter how smart you are, what your grades were. It really doesn't. So, you know, there's a lot, you know, I think we're saying the same thing over and over again, which is get an IEP. But if you qualify,
I mean, that's the, you know, I mean,
right.
like, I
No
think
one's
that answers the
handing them
question. It's
out.
like, which is the stronger document?
No one, the
IEP.
stronger, the
Right.
IEP, the IEP
Right.
is a stronger document, and no one's handing them out. So you can't get one if you don't qualify.
That's right.
Okay? You
Right.
absolutely cannot get one if you don't qualify. So why not try to get one? Because if you do get one, you know you qualify.
Right. Right.
Right. And sometimes you can qualify, and it isn't an easy process necessarily to get a yes, but there are ways to address that. I noticed in the Q&A someone had asked about, you know, I asked them to evaluate, they refused to do the initial eval, and, you know, what do I do? And there are, you know, there's dispute resolution processes that you probably know about. Part of it, one thing that people can do is even file a state complaint. That's something parents can do on their own. It's really simple. The thing is that it's helpful to have backup documentation. So for anything, if you're looking to have your child evaluated for special ed, first of all, put it in writing and send it to either the special ed director or someone. Having a conversation in the hallway with the teacher, and the teacher says, no, I don't think your child needs special ed, doesn't count. So it's like, unless it was in writing, it never happened. So you send an email and you say, I want my child evaluated in all areas of suspected disability. They have to convene a PPT. It cannot be decided apart from the PPT. You get to the PPT, they say, no, we don't think anything's needed. And then, you know, it's like, okay, you're stuck. So you can maybe get letters from the child's therapist or a doctor. Maybe you had a private eval done. Pediatrician, absolutely. They can say this child needs to be evaluated. And maybe the school still says no. If you file a state complaint and say, you know, violation of what they call child find, you know, the state can review the complaint and make a decision about whether the district should evaluate. That's probably the simplest path for most parents. And quite frankly, you know, we sometimes talk about due process hearings. Parents going on their own win about 4% of the time, and 96% of the time they lose if they don't have an attorney. State complaints, it's more like 50 or 60% that they get a favorable response. So just throwing that out there, maybe sometime SELF will do a program on state complaints.
That's a great idea.
Okay.
I'll tell someone to get on that.
Yeah.
Okay. Tell yourself.
Tell myself to make a
Yeah.
note and get on that.
Right.
The
I
other
mean,
thing, Diane, that you mentioned, if the team says that they don't think that they need to test, I think it's really important. Parents are part of that team. And if you do not agree that the district is making a good decision, you don't have to, you should say, I don't agree. I mean, we don't have to use the legal term of prior written notice, but you absolutely should say, I am not in agreement with this decision. And you should make sure that they document it on, you know, on the notes or in the meeting.
in the prior written notice
Written
that
notice,
you're not going to
yeah.
talk about, but I will, that they have to document it in the prior written notice, which in Connecticut is now a separate document. You will not automatically get your prior written notice with your IEP as you have historically. It's going to be a separate document that you're going to have to look at. And my solid guess is it will not arrive at the same time as
So
your
far it has.
IEP.
Mine are not.
Okay.
Just a guess. But
Okay.
so, you know, you need to be aware of that's where they document. If they don't write in the prior written notice that you made a request and it was refused, then next year when you call me and say, I've been asking for this for years, and I go look at the documents, I'm going to say, no, you haven't. So
Because they write, the team was in agreement, right, Dana?
exactly,
I know.
the team, not the school-based team. You can say the school-based team, be clear on which part of this team, but parents are an equal participant in those meetings. They are equal team members to the school.
And are you talking, do the parents play a similar role in a 504 meeting as they do IEP meeting? They have the
It's
same rights?
worse. Families don't even have to be part of the team.
Yeah,
504.
They always
504
And
Yeah.
they basically, a 504 plan does not have to be in writing, although it always is in Connecticut.
Yeah.
Parents, it has to be made by a group of people, but it doesn't have to include the parents. If the parents make a request,
So that was
They-
one of our questions. Who are the required members of a 504 team?
just whoever the district thinks they need.
Really?
There's not, and this obviously a
The
PPT.
reg ed teacher, maybe, like,
Well, I was going to say
Maybe.
very often they have a reg ed teacher. Very often, sometimes they'll have like a guidance counselor running it. Sometimes it's the director of special ed. You don't know, but there's no set group
Which
of
is not
people
supposed to
that
be.
have to be there at a 504 meeting. And obviously with PPT, you have to have a regular ed teacher, a special ed teacher, the parent, and someone who has the ability to commit resources, which in some districts, it's only the special ed director who could do that.
Right.
So having the vice principal be the administrator in your meeting isn't necessarily enough
So is
because they
there-
won't be able to.
I
Yeah.
guess just putting it bluntly or, directly, is there any reason is there anything you can get from a 504 that can also be covered with an IEP?
No, because you're covered by 504 if you have an IEP as
And
well.
you have an
Part of your
accommodation
IEP.
is
sorry,
your
go ahead.
accommodation. Right,
Yeah,
part of your
yeah.
IEP is your accommodation, so you get all of the accommodations plus the specialized, goals and objectives. You're clearly defining your present level, so where are we functioning now? And you're moving to what do we need, to what services do we need, what supports do we need, so we can fully implement, that
guess-
program.
Would you say that sometimes a 504 is desirable for a student in their path to become more mainstream? So like a student might start off with an IEP and then go to being a student with a 504.
Well, my daughter's like that.
Yeah, that means some kids will
I mean-
always need accommodations
Right.
You
So
know,
would you
like-
ever say that's kind of,
as a human, but like I think as Virginia said, you can get everything you need in the IEP. There's nothing you can get from a 504 that you can't get in an IEP. So if your child, and it's not an IEP light 504, it's
Mhm.
if your child requires accommodations and they met all their goals and objectives, so they no longer need the accommodations, great. But if your child met all their goals and objectives and they still need extra time,
then
then
get
they go to a 504.
exactly. That was
But it's
more,
not like a step down plan. It's not like
Yeah.
we're gonna transition them back into whatever. But no, so it's
And to further complicate everything, there is special education in section 504, but it basically, it gets really confusing because section 504 existed before IDA. So there's a lot of overlap between the laws, and there's special instruction in 504. You can have goals and objectives. There's no prohibition against that. They're just not required. And the part I like is that the district's responsible for meeting the child's needs regardless of whether or not you have a written document. So, but the thing is that it can get confusing because staff will say, we can do anything in a 504 plan that we would do in an IEP. And the thing is that, okay, so technically you're right, but if the child needs special instruction because of a qualifying disability, they have to offer an IEP. They can't just do it through a 504. And, and we find ourselves saying, yeah, but we want goals and objectives. So, but it is.
If parents in the
it's
school
confusing.
district agree to a 504, that school district can still get in trouble because if a child requires an IEP, they should have an IEP.
Mhm.
There's no
Right.
side deal, So
Right,
yeah,
right.
it's just important.
so if a district gives a student a 504, but that's really a child that has more, they're in violation of child fine. They're not,
Yeah.
they're not providing the service to that child. Okay.
Yeah.
The one thing
Yeah.
I just wanted to say before we end is read your documents, guys. I think we say this a lot in some of these webinars, but regardless of what you have, you know, you should be reading the 504, even that PPT meeting that you maybe went for the IEP and they said that weren't eligible. Read the minutes, because it'll be shocking how it's captured there, and you're sitting in that table too, and you know, again, document. I don't think that's how the minutes are inaccurate. This
And to
didn't
that point, Virginia, with the new IEP, those summary minutes are now optional. So you'll hear all about this in the next webinar from Self, but they're optional. So ask them. Right.
And the
Ask
thing
them
is
to do it.
they may still be writing them, but they are not automatically passing them on. So absolutely always ask for the meeting summary if it exists. The main thing, again, if it's not in writing, it never happened. If you said something stupid in the PPT and it's not, and they didn't document it, never happened.
Don't worry about it.
But yeah, so, but it's also goes the same way. You need to document any important areas of agreement or disagreement following the PPT.
Yes.
And sometimes it's funny, once there's a paper trail, sometimes if the district said no before, but now you have the paper trail about the basis and your request, sometimes they change their minds.
I also strongly recommend that you tape record the meeting always. And there's a lot of information going back and forth. So you kindly let them know you will be recording and you're happy to share a copy of this recording. That is imperative, especially with what is going on with the new IEP.
I have a question. What if you are, you know, you request an evaluation of your child to be evaluated for special education. The district, you know, does the evaluation and decides and doesn't believe that your child qualifies for special education. Maybe they give you a 504 instead. Maybe you get nothing. What is your alternative? What's your next steps in that process if you don't agree?
Well, Diane talked about the complaint process, right?
Right. So there's So you could, it depends, again, it all depends. You're never going to talk to any one of us and hear anything other than it depends, because it really, really does. And there are pieces for which you could file a state complaint. There's also you ask for an IEE, which is an independent educational evaluation, which is a whole other webinar. And then, you know,
we already did that webinar.
Yeah.
And it's on it, and you can have a recording of it if you'd like.
Yeah, there you go. So yeah, so there you can do that. You can file for due process, which I would strongly recommend you speak to a special education attorney, someone who only does special education, not someone who's helping you out but does something else. You know, somebody only does special education. And yes, that you have options. You can refute it, and those options are much stronger and much more likely to be successful than under 504, because in Connecticut, and Diane touched on this, we're a pretty good state overall. Even if you're miserable with your school district right now, in the grand scheme of things, and all 50 states and everywhere, like we're pretty good. So you might not recognize that you don't have as many rights under 504 because your district might do more than they're required to do. But when it hits the fan and you're upset because it's not going right, now suddenly you don't have any rights to go after them.
Right.
So,
right. And if they talk about, you know, in terms of the complaint resolution process,
yes.
For 504, there's the district. You can have the district assess whether or not they're meeting your child's needs, and you're saying they're not. And gosh, I wonder how that's going to go. There's also the Office of Civil Rights, and you can file a complaint with them.
Yep.
But they're going to take as long as they want to make a decision about it. I mean, literally, it could be years. You can't, you know, whereas with an IEP, or anything related to special ed, it doesn't just have to be an IEP. You can file a complaint with the state and they have 60 days to issue a decision. Or there's a hearing with an independent hearing officer as opposed to somebody who was hired by the district. You know, so there are definite differences in what you do with dispute resolution. And as everyone keeps saying, you know, there's the independent eval. There are just things that you can have that you wouldn't have otherwise.
Yeah.
I have a few cases like this going on right now. What I do is I get the FERPA docs, right? You file for the FERPA docs. And there are red flags all over the place, usually starting in kindergarten. So you listen to the parents, you encourage them to follow their gut.
Yeah.
They are already often been beaten down and told they're wrong, but they know their kid, they know what's going on at home. So you really need to listen and find out what actually is going on at home. Can they do their homework independently? How long is it taking? How, all those types of questions. Who are their friends? Are they getting invited to birthday parties? You can look at the FERPA docs, and you have to do a comprehensive analysis to look at the procedural and substantive violations and the red flags. And you're going to see them. You're going to see them. And then that often, and that's where the information comes from to try to go to the next step. And that's often how I approach these things, these cases.
So as we come, we're nearing an end. So we've covered a lot of important information here. So if we could just ask one final question, and I think if everybody, each panelist wants to take a chance to answer, I guess, what would you say are, the question is, what are the three main differences between a 504 and an IEP? Who wants to go first?
Well, this is, yeah. Okay, the three main differences, I was going to say in Connecticut, because there are more differences in terms of the laws, but the main thing is that if the parent makes a request and the district says no with Section 504, the district does not need to provide a basis for their answer. They don't have to document something and tell the parent what record, what is the basis for the refusal that has to do with the child. That's one. The other is that, if with the initial evaluation, with a 504 initial evaluation, the parent is not entitled to an independent eval if they disagree with the district evals. On the other hand, if with the special ed process, if the parent disagrees with the district evals, they have a right to request an independent evaluation at district expense with someone the parent chooses. And then finally, as we were just talking about, the dispute resolution process is very different. There are state complaints, there are due process hearings with special ed, and many more limited options with 504 in having the district investigate, or the Office of Civil Rights, who takes forever. Yeah, so
well, and the other
those
thing,
are my three.
Yeah, and they were good three. I was going to say the length of the document, an accommodation plan, a robust one. I maybe we're going to get to 3 pages. An IEP has, very set pages that we're working through. So it's a bigger, more comprehensive look. Goals and objectives that Diane mentioned, you're going to be getting measurable, meaningful goals and objectives based on the evaluations, based on the present levels for an IEP. You're not having that with a 504. And your services, you have a grid. It talks about, or lists out where the service is going to take place, who's doing it. What is it? A small group? Is it, one-on-one? Like it's very specific, and you can do that to a certain extent in accommodation plans, but you really are going to have somebody that's spelling it out. A lot of times they'll write counseling as needed. You're not going to see that, or I hope you won't see that on an IEP. So those would be, 3 additional ones to Diane's 3.
I agree with Diane and Virginia. I mean, specialized instruction is a primary difference. Evaluations and your rights to them is a difference, and your dispute resolution. But the other piece, or I guess it kind of ties into all of that, is accountability. I find that with an IEP, there's a lot more accountability. There's more obligation to measure the child's progress. There's more obligation to understand where the child is to begin with. There's just more, there's more accountability. And if the school doesn't do it, you have a path to go down. You have a way of recouping that in some way, shape, or form. So, it's better accountability with your school district.
Yeah, I concur with everybody. I would like to just add that the IEPs, right? And once you have met those mandates, independent living, the ability to go on for higher education or training and be able to be gainfully employed to the, but if you have a disability, has a substantial impact on major life activity, which also includes breathing, sleeping, focusing, concentration. The list is so vast and broad. You have that protection for life. Not only forever, wherever you go, in your employment, everywhere. So that ADA 504 language, try to familiarize yourself with that, and that will follow you through life if needed.
Thank you, everyone, so much for joining us this evening. Thank you to all of our panelists for this lively and interesting discussion. Always such a joy to see all of you on screen and have these really, really interesting and in-depth chats. Our next webinar, as I mentioned, is on December 7th at 7 p.m. The new Connecticut IEP with attorneys Jeff Forte and Jill Hornig. Hope to see you all there. And thanks so much. Good night.
Thanks.
Bye. Thanks.
Night.
Thanks.
Bye.